Alright everyone, we start off today with the prelude to what could be very, very good news. Now this is something, link in the description, archived of course, you can read through it. The Chevron Defense is in focus at SCOTUS. People need to understand, a lot of times everyone bitches about the federal government, oh my god, the government's, screwing with us, etc., etc. They don't seem to realize that most abuse that happens to people on a regular basis is state law, because the 10th Amendment allows the states generally to supersede federal authority entirely. So a lot of the laws you have to deal with are actually state level. Like, for instance, the drinking age is 21 in the United States, or the age to purchase alcohol. Of course, the states differ on drinking as well. That's not because the federal government has mandated it. It's because the federal government said you can't have any highway money, even though you're paying taxes into the highway fund, unless you keep the age at 21. So if you lower it to 18, or you could lower it further than that, you could abolish it altogether, you won't be able to pay for your highway system and your state economy will fail. It's a workaround for the 10th Amendment, utilizing a little bit of the on-the-edge Commerce Clause argument. It's always a little bit screwy. Maybe SCOTUS can tackle that sometime. The other main component, at least as far as there's abuse at the federal level, is bureaucracy. And one of the reasons that the U.S. bureaucracy is so expansive is because of the Chevron Defense, the two-step take that courts use in order to determine whether a federal regulation is actually legal or not. The problem is that unless there's very clear constraining language, it's a hodgepodge of decisions all over the place with regards to the federal court system with the application of federal bureaucracy. So here's what happens. In the olden days, back in the late 1700s, up through the creation of the bureaucratic proto-state, roughly in the mid-1800s, decisions, laws, etc., they were made by Congress, so a rule's been incepted, it's been passed by a governor at the state level, or locally, by a mayor, potentially, or by the president. It's been upheld by the courts if it got challenged, so it's law. And then it gets enforced. It gets enforced by police or whatever. What has been done since the creation of a bureaucratic state is that you create federal bureaus. So Congress doesn't make a law, it makes a bill creating a bureau, and then it grants it certain powers. When those bureaus go beyond their scope, like with the OSHA mandate, etc., when regulations go beyond that scope, there can be legal cases. The problem is that the application of whether the extension of the regulatory authority granted by Congress simply by creating an agency falls within the purview of the agency. So a large proportion of all the laws that you have to deal with are effectively nothing more than bureaucratic regulations. That's a large proportion of them. Bureaucratic regulation encompasses most of the day-to-day abuse that Americans suffer under. And then, of course, state law is second to that. Actual federal law beyond creating and potentially expanding bureaus is a distant third. It gobbles up a lot of tax money. Guess where a lot of that goes to? Oh, that's right, it's to all of the regulators. All of the millions of bureaucrats in the United States that in many cases really aren't necessary and sometimes work for bureaus like the FBI that were never even incepted to be permanent to begin with. The FBI was not incepted to be a permanent institution. It's just continuously funded and expanded over time. This is why I think we also need a sundown law for various bills. So in other words, if Congress can't find the votes to reauthorize an agency after, let's say, 4 years or something, or 10 years, then it goes the way of the dinosaur. Therefore, compelling things you uphold, things that are necessary, things that are actually proper. Other things, generally they should sundown. The inception is that if it's important, then Congress can get its ass up and it can vote to reauthorize and refund an agency or extend a bill or something, and there's no problem. And if they don't have the gumption to do that, if they have to prioritize because we don't have enough time to maintain the entire billions of pages of laws, we can't do it, well, then that's perfectly fine. Then sundown the ones that are less important and prioritize the ones that actually make sense. The Chevron Defense, in my opinion, and the repeal of it by SCOTUS would cripple the regulatory state in part by reconstraining agencies and bureaucrats in general. It would begin restraining those rules at least somewhat. By allowing different litmus tests to be applied. Firstly, the filing here by the plaintiffs against the regulatory state it's based largely on inconsistency more than anything else. It's based on the fact that the actual methodology of the Chevron defense used by regulators and by the government is all over the place. The courts can't apply it. It's impossible. And so it can't possibly be legal because it's effectively, of necessity, it's being misapplied in one direction or the other. And so SCOTUS wants to potentially reassert the actual parameters of what constitutes acceptable overreaching by a federal agency and what would be unacceptable overreach. In my opinion, the fact that they granted the motion to proceed with this quickly, and that it was all the conservative justices signing on to that, points to the death of the Chevron defense. That is, that the regulatory state is likely to lose this round. Now, Congress will probably patch things up afterwards because they love their regulations. It allows them to work less. When a bunch of bureaucrats are effectively doing Congress's job for them, and the only thing they have to do is debate over how much funding to give the regulators that they've empowered, well, no wonder they have so many vacation days. There's not as much work to do as you think. Why do you think that they have the time to go on TV every single day? Half of them don't even show up for the average voting anyway. They don't even care about their jobs. They're a bunch of losers, basically. A House member is even lazier than senators, by the way, generally speaking. I think there's a good chance that SCOTUS will strike down the regulator's ability to use this particular legal defense. In which case, yes, the regulatory state will be dealt a blow. This is significant. This is the most significant case they're taking up since Bruin. And is on the same order of magnitude, actually, as far as the potential fallout. Again, while Congress is very regulation-loving, and that includes a plurality of Republicans, everyone, don't be a fucking hypocrite. It even includes some elements of MAGA. I see them saying the FBI needs to be audited. I see them go after the IRS sometimes, but I don't see them making that same argument for a hell of a lot of other federal agencies. Hint, hint, about 20% of them shouldn't even exist, and the rest of them should probably take a 20% pay cut. If we just accomplish that, we can call it a day and do more later. That would be a day one goal if I were in the U.S. presidency. I'd be pushing that issue, even though it'd be DOA and the uniparty-controlled chambers of Congress. So I think it'll fall. It's just a matter of when they make the decision, and that's good. That's a good thing. It won't be quite as ground-shaking after it is tied up in further consideration, but the main defense of the bureaucratic state that we suffer under would be gone, and so it would be harder. It's sort of like Bruin. Bruin has not, even though an interpretation of Bruin as suggested by the people who literally fucking passed the decision, even though that interpretation would nullify virtually every attempt at gun control that's currently being passed, it doesn't block them. It simply makes it easier to litigate against them. It's still a slow process, it's imperfect, it's tedious, but it's better than it was before because you have created a legal precedent saying, hey, if there's no long-standing tradition of this gun control in the United States, then you can't have the gun control. In other words, it caps the amount of gun control at whatever's traditional. Well, the real answer is there is no traditional gun control in the United States. There was none prior to the 1870s whatsoever on the federal or most state books. There's not much of a tradition, so yeah. And most gun control dates to a time in which plenty of people who are currently alive today were already kicking and breathing. With Chevron defense falling, potentially, that's the hope. The regulatory system will also have a similar legal burden to the anti-gunners, which is to say they don't lose every battle immediately, but long-term they tend to lose more than they win. The regulatory state will be constrained more, and that's definitely something that we need. That's about all. Peace out.